Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I'm here every Sunday from 8 to 9 a.m. to provide landowners valuable information that you need regarding the natural gas development here in Pennsylvania. So if you're looking for a show for landowners, then this is the show for you. And at the Clark Law Firm, again, my focus is solely on landowner representation. And I continue to represent landowners all across the state of Pennsylvania for such items as gas lease negotiations. I've negotiated hundreds upon hundreds of gas leases. Same thing with pipeline agreements. I think we're closing in on, I say this I think now every week, but closing in on about 50 different pipeline companies that have negotiated agreements with across the state of Pennsylvania. And so, I do a lot of pipeline work. I have a lot of active files all across the state in pipeline negotiations, and touch on it a little bit today, but today's not going to be a pipeline show. But if you are approached with a pipeline agreement, to sign a pipeline agreement, please make sure that you're going to get some assistance from somebody that can help you, who's experienced, who understands the market, understands how to assess your leverage, and can give you the proper guidance and strengthen that agreement to get you the most compensation, but also for the best terms. The terms of the agreement are very important and critical. So you want to make sure, and that is something I will talk about today. I had a client who had entered into a pipeline agreement. Well, actually, they didn't, but it was an individual before they bought this property had entered into a pipeline agreement with the company in the 1950s or 1960s. And I'm going to talk a little bit about that today because there was some language in that agreement back in the 50s and 60s that was negotiated, and it wasn't negotiated very well, but they got lucky because there was one good term in there. And that was a term that limited the size of this easement and the areas in which the company could operate. And because of that term, here comes the company back, literally, 60, 70 years later, and says, hey, we want to do some work on the property. And in this agreement, they had the right to lay 2 pipelines, but the problem the company had was in order to lay this second pipeline, they wanted to get some extra workspace, some additional space that wasn't authorized in the original agreement. So then as the landowner today, like I said, 50, 60, 70 years later, the landowner today is looking at this and says, okay, well, I have the ability to say, no, I'm not going to grant you this permission to use additional space on my property and cut additional trees and make this area wider. They could simply say no, or they could say, you know what? Well, I don't want to do this. I really don't. But if the deal is right, if the compensation level is right, well, of course, maybe I'll reconsider. The idea of, everybody having a price, I mean, it's not always true, but if there's a price that the company's willing to pay, which is far more than what these damages are going to be, and it's going to be an impactful price and change your circumstances, then hey, this is something that may change your mind and say, you know what, I'm willing to do this. But you need to have that opportunity. And I say here, using this example of 50, 60, 70 years down the road, well, it's not always 50, 60, 70 years down the road. Sometimes it's a couple years down the road. Sometimes it's 5 to 10 years down the road, and we see those too. So it's so important when you're negotiating a pipeline agreement and any other agreement, but we're talking about pipeline agreements here for a moment. It's so important that you negotiate the strongest possible agreement. And it's really, really hard for a landowner to operate in a vacuum of their particular case. And maybe you're fortunate because some neighbors around you, you have some information from them, but you're in a vacuum, but a little bit bigger of a vacuum. So we're talking about looking at this in a broad picture of 30, 40, 50 companies. How have they handled this? What can you do? What can you do to maximize your particular situation? That's really, really important because a good agreement today can pay enormous dividends in the future. And again, not just financially, but to limit the areas of operations. I get the calls, unfortunately, too many times. I get the calls from landowners who say, wow, the companies came back and they want to do something that I never thought they could do, or they told me they were never intending on doing at the time. But unfortunately, Many people have heard this. The companies say, well, plans have changed. So if you listen closely, when the company representatives talk to you now, they will almost always say, well, we intend to do this. We intend to do this. The schedule is this for now, but it's subject to change. Remember that. And if something isn't subject to change, well, then you look to add it to the agreement. I'll give you an example, something very, very basic. Company comes out to you and says, hey, we want to put one 12-inch gas pipeline in an easement area across your property. You say, okay, well, that's all the bigger it's going to be, 12 inches. Yep, all we intend to do is one 12-inch pipeline. And so, okay, you say, well, that's maybe not so bad, and they're going to pay me, say, $25 a foot, and I think that's a good deal. And times you can get much more than that, but we'll say you're going to pay you $25, $30 a foot for one pipeline. It's in an area that you don't have a problem with. It's right on the border of your property. You say, okay, I'm willing to go ahead, and at this price, I think I'll go ahead and do this, because all they want to do is one pipeline. It's a smaller pipeline, only 12 inches. So, okay, I think I want to do that. Well, what happens in a few years from now whenever the pipeline company comes back and says, hey, we want to put another pipeline in? And you say to them, well, company, you told me back in 2019, you told me back in 2014 that you only wanted to put in one pipeline. And now you're coming back and saying you want to put another one in. And they say, well, plans have changed. And plans have changed, and if you go back and you look at your agreement, it says that we can put in a pipeline or pipelines in this easement. In fact, it doesn't even limit it to 2 pipelines. So now they're coming back and they're going to put a second pipeline in. And most agreements are written that they don't have to pay you again for that second pipeline. Some agreements will say they have to pay you the same consideration or the same damages again in the future, but many agreements do not. So here they come in and they say, hey, we want to put another pipeline on your property. And you say, well, I thought you weren't going to do that. That's what you told me. And they say, well, plans have changed. Or, not that this matters, but a lot of times, these companies get bought out by other companies. They sell their assets to other companies. And you get a new company coming in and they're going to do something totally different. So intentions mean something, but not a lot. What means a lot is, what are the terms of the agreement? What is written down in your agreement? So, rewinding back to 2014, today, when the landman and the company representative says to you, hey, we only want to put one 12-inch pipeline on your property within this easement area at this location. And you say, okay, for the compensation you're offering me, again, I think this will work. So you'll say, okay, let's go ahead, let's get this done. Well, when you're going to say, let's get this done, you say then before that, you say, hey, okay, that's what you want to do. Well, let's do this. Let's put in the agreement that you have the authority, that I am granting you the authority to only install one 12-inch pipeline for natural gas within this easement area as shown on this map, which is attached to this document. And then watch out, because you may get this, we want to buy this easement. We can't limit ourselves to just one line. We can't also just limit ourselves to 12 inches in diameter because things may change. That's our intention now. Well, land guy, 5 minutes ago you told me this is what you were going to do. Now you're telling me that you can't put that in writing and you can't make any commitments. Well, that unfortunately is all too common. Again, I am attorney Doug Clark. You're listening to All Things Marcellus. We're here every Sunday from 8 to 9 a.m. talking about, here I always go, break off of my script entirely, but I got on this roll and I want to finish this up in this segment. So, okay, it's so important that when you are contacted that you get some assistance with somebody that knows what they're doing, that can help you out. because many times the situation I just described occurs. And what happens is a landowner will call me and say, hey, I'd like you to represent me in these negotiations and do this contract. I say, okay. And they say, well, we've agreed it's going to be one pipeline only, 12 inches, and here's what the compensation is going to be. Here's going to be the location. And I say, okay, that's great. Let me go ahead and get all of this stuff confirmed, and let's get this in the agreement. And then I go through the process, and then unfortunately, I get the same kind of response. Well, yeah, that's what we intend to do, but things may change. We can't put that into the agreement. So you got to be super careful. It's important to you, and it should be, and if it is, but it should be important that you want to limit them. You don't want surprises. A regular listener to the show knows I always say, let's eliminate surprise. If you're willing to enter into an agreement and you're happy with the terms, well, that's a good thing. Then you enter into that agreement. But you need to know what the agreement says, and you need to make sure that you're not going to be surprised in the future. You need to understand all these little nuances of the agreement. These companies know what they are doing. They know what they're doing. They know what they're doing. They know what they're doing. They've done this and continue to do this across the country, and it didn't start in Pennsylvania. That's just where we are today. So they have a history of, thousands, tens of thousands, hundreds of thousands of negotiations in the past. And they use that education and history to train their people, to draft their agreements. And they come out to you as the landowner and present it to you in the fashion that is most advantageous to them. You have to understand that when you're dealing with the company. You just have to understand that. And if you're a person that says, you know what, I don't care. I don't care what you do. I don't care where you do it. I don't care about anything. Go ahead and sign. Just sign whatever it is that they give you. I think that you may find that you may start caring in the future in most cases. But if that's how you feel, that's how you feel. But I talk to people all the time, who are so frustrated for so many different reasons. And what kills me at times is that people are falling into the same traps with these secondary agreements, which are very important. I don't mean to belittle them as secondary. I mean, following up the lease agreements, these roadway agreements, these workspace agreements, these pipeline agreements, these surface use agreements. People are falling into the same traps with these agreements. Now, with most of these agreements, sometimes with the pipelines, I have clients that get hundreds and hundreds and hundreds of thousands of dollars for one agreement. Not all the time, but many, many times, depending upon how important it is, how much property they have, a lot of factors play into that. But these agreements also, it's not always about money. Money's a fundamental part of this process, but it's also about, you say, company, you're going to put this right away here. Let's get it on a map and let's guarantee that. And if they won't do that, then that's a sign that they may not put it there. If they won't agree to a 12-inch diameter pipeline, that's a sign they may go bigger. That may not matter to you. So if it occurs, you're not going to be surprised, and you're okay with that. If they won't agree to one pipeline and one pipeline only, what does that tell you? That they may put in more. And if they won't agree to two only, then they may put in more. You have to look at these things. And if a company is out there and they're willing to pay you, say, $30, $40 for the first pipeline, and I hate to use those numbers because it could be 50, 60. They should pay you that for the second pipeline. And in almost all cases, we get equal or more for a second pipeline. So you have to take advantage. So if you're getting $100,000 and you say, that's okay, I'm happy with that. Well, if it just took a phone call and a little bit of work and they put another pipeline in and you get another $100,000, why in the world would you not do that? Why would you not do that? It's crazy to me. So we want to make sure you're educated, you understand, and you're getting the best possible agreement. All right, so I broke way off a script there. I hope everyone's listening. You get a pipeline agreement, please take steps back, contact somebody that can assist you, whether it's me or somebody else. Get some high-quality assistance that can help you and guide you, and make sure you're maximizing compensation and terms, because they all matter. Again, you're listening to Attorney Doug Clark. This is All Things Marcellus. We're here every Sunday from 8 to 9, and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And again, we are here with you. I am here every Sunday from 8 to 9 a.m. to talk about landowner issues, kind of tell some stories and educate you on some things you need to be looking at. I say all the time, you got to pay attention because the markets are always changing. And I've been doing this show now since August of 2010. And if you listen to some of the earlier shows, that information, much of it may be relevant, but some of it can get dated because this process is evolving. So what we've seen, somewhat like gas leases and years back where people were getting $5, $10, $25, $50, well, obviously there was a peak where they went up to close to $6,000 in that range in certain areas. Well, the same thing like we're seeing with pipeline agreements and some of these roadway, water line, and these other agreements. As landowners become more savvy, companies are having to account for that by offering additional compensation and better terms in a lot of these agreements. Unfortunately, we can't, and we're trying, and I promise you I am trying to speed up the savviness of everybody here, of our landowners, and of what we're doing to say, hey, let's if more people were thinking about this and more people were getting educated, this process of increase of compensation would be sped up, and you would see that landowners would be getting more money right from the beginning. But unfortunately, we have a lot of people who fall into that same trap. The big sell point is always from the company is always, well, we want to get you royalties. We want to get this pipeline in the ground and get you royalties. We want to get this well site drilled and get you royalties. And as we do that, we also want you to sign this really bad release agreement that releases us from any liability in case we screw up. But, don't pay much attention to that. Pay more attention to the fact that we want to get you royalties, 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 royalties. We want to get royalties. Listen, your royalties, if you're in an area where there's going to be royalties, I promise you, your royalties are going to come. But we need to make sure that you have good, strong agreements. So there's always this, it's uniform across the state, this rush. We need to get this done. We need to get you royalties. We need to get you royalties. We need to get you to sign this agreement. Well, remember, look at the agreement. Similar to how I started in the first segment about the pipelines, and when a company says, well, we want to only put one pipeline, 12 inches, and we're going to put it over here. Well, how about a pipeline as far as timing goes? We want to get this pipeline in the ground. We want to get you royalties right away. We plan on starting drilling in starting to install this pipeline in 2 months, 3 months, 4 months. You say, oh, great. Okay. So this sounds like a good thing. Let's go ahead and get this done. But since you want to go and drill so quick, let's go ahead and do this and put a term in there not drill, but lay the pipeline. Let's go ahead and put a term in this agreement that says that you have to start working on the pipeline. Now, you said you're going to start in a couple months. Let's be fair and reasonable, and let's say that you have to commence construction of the pipeline and installation within 1 year from the date that we sign this agreement. And then all of a sudden, watch the company say, or the landman, we can't, we're not sure, things can change. Well, wait a second, landman. 5 minutes ago, 2 minutes ago, 1 minute ago, you were telling me how you wanted to get me royalties, how you guys wanted to get this pipe in the ground, how we needed to get this done. And if we can't get the pipe in the ground, how we can't get royalties. But now I'm telling you, okay, let's go ahead and work this out in the next week or two and give you 1 year in which to start to give the company, but you can't do that. Well, how is that the case? How do you tell us that you're going to do it in 2 months, but yet you need a year or more or 2 or 3 or 4 or 5 before you're going to start working? How come? Because, it goes back to the beginning. Plans may change, things may change. They'll say things like, the DEP and permitting, we could run into permitting issues. You hear that all the time. So remember, there very rarely are there occasions where there's some sort of true emergency where documents need to get signed right away, especially when you're presented with them for the first time. I've been involved in, I mean, honestly, 50, 100 plus, easily, 100 plus cases where the client comes to me, landowner, oh, they're in a real big hurry to get this done. We submit something to them, make some requests, and this process takes many, many, many months. And it's not from our end, it's on the company's end, because the reality is they're never in a hurry. What they're in a hurry for is for you to sign a very company-friendly agreement. And you need to make sure that you sign a fair landowner agreement. Very rarely, I mean, very rarely, like a 1%, 2%, sometimes less, like even in that, I'm retained to do a pipeline agreement in almost every single case. Once we're moving forward, because the landowner wants to do this, we always end up reaching an agreement. The agreement that we reach is a lot different than what was presented to the landowner. Sometimes it's a lot different because of compensation. Sometimes it's a lot different because the terms, the language in the agreement is much better and much more fair to the landowner from the landowner perspective. But again, sometimes this compensation goes up. I mean, I don't want to promise this. Sometimes it goes up a little. Sometimes it goes up by 10 times or more. It just depends on the circumstances, and that's what you have to understand. You have to understand your circumstances. I am attorney Doug Clark of the Clark Law Firm. You are listening to All Things Marcellus, and I'm here every Sunday from 8 to 9 a.m. on these stations. And also, I want to just, I started at the beginning of the show, so, it's not going to be a pipeline show, and I think I've done nothing so far but talk about pipelines. I'm here looking at my kind of intro script here, and I'm so far off of that. But I want to finish this with pipelines. We get a lot of this, and this is kind of, sometimes I think things... we see them a lot from our side and say, it's just something really common. But again, when a landowner sees something, they're seeing a lot of these things for the first time. And that's why I always say to everybody, if you're asked to sign anything, you can always send it to me. I'll check it out and say, hey, this is a big deal. It's not a big deal. You may want to get some help. Yeah, this isn't a big deal. Kind of give you a little guidance on that. And that's part of the show too, is to make sure that you're at least tuning into, some of these issues, but not any specific legal advice in any fashion. So one of the things this week, and we get these all the time, but just something I thought I'd bring up, is a landowner client of mine. We're working on a couple different things with one pipeline company and a gas lease amendment and modification, but also a pipeline agreement with another company. And then they get a document from yet a third company, another pipeline company, asking for permission to survey. Now, again, this is not specific advice for anybody, because what you may get as a permission to survey may not be exactly what I'm talking about here, but a very common document that landowners will receive from companies is a document entitled typically permission to survey or something very similar to that effect. And if it's coming from a pipeline company, typically what they're doing is they're asking, hey, can we get out there? We want to walk around on the property, maybe do some real survey work with some surveyors, maybe delineate or identify some wetlands to see if your property would be a good property for us to use for a pipeline across the property. Can we do it on your property? So, number one is you want to understand, is the company requesting survey, is that a company that's looking for a pipeline that may have the ability in the future, may have eminent domain power, the power of condemnation, to say that even if you don't want it, that they can get approval from the government that they're allowed to do this and you can't truly stop them in almost all cases? Is it that type of pipeline, or is this a pipeline from a typical pipeline company that is connecting wells and transporting gas out of the area and that they would never have eminent domain? That's what I want to talk about today. So you get a survey permission form, and it's often like a form, and they say to you, hey, we'd like to survey your property. Well, this is some common advice and discussions that I have with clients who have this situation. Say, look, if this isn't an eminent domain potential line, the survey permission, if you know with all certainty in the world that you're never, ever going to agree to allow additional pipeline on the property where there's not authority to have it, then there's no sense signing the permission, survey permission. Just say, hey, thanks, but no thanks. However, If you say, look, I really have no desire in the world for a pipeline on my property, no desire at all. However, if the company wants to pay me, hundreds of thousands of dollars, and it's going to be in an area where I don't mind it so much, well, maybe I would consider it. Well, if you're in that position, then you may want to go ahead and say, okay, I'll let you guys survey. But in that process, if you talk to anybody, you can just say, look, I'm not really inclined to this. You guys can look around, but I'm going to tell you now, I don't think we're ever going to reach an agreement. But if you want to poke around, you want to walk around, you want to check it out, go ahead. But always remember that you can say no in the future if it's that type of line. And that's what's important. We have to identify that. So when they come back to you and they say in the future, hey, you know what? We surveyed your property and it is a good property. We'd like to run a pipeline on the property. And you say, okay, well, where are you talking about? And they show you a map. And you look at that map and it's a place that you would never want the pipeline. And you say, you know what? Thanks, no thanks. I'm not going to agree to that, but thank you. What'll happen then is, the most important advice that I give my clients at this point is when you get involved, if you're involved in any of these discussions, please do not talk compensation. Do not talk compensation, because every interaction that you as a landowner have with the company landman or representative, as soon as that interaction is complete, that representative will do a summary of that contact. And if you say or you give an inclination that you're agreeable to $25 a foot or $30 or whatever that case may be, that will come back to haunt you in all future negotiations or discussions. If you're agreeable to a certain location, there's a good chance that's going to come back to haunt you if you want to change locations. Because what happens is the landowner will then maybe come to me and says, well, I'm thinking about this. And I say, okay, well, first question, did you agree to compensation of any kind? And hopefully the person says, nope, not at all. Or if they say, yes, I agreed to $30, and I say, well, $30 a foot. I say, routinely from this company, we're able to get $50 or $60 a foot. And then it's just more difficult to get that number to change because the company says, well, your client agreed to this. Now, an oral agreement isn't an agreement that's going to be effective in these circumstances, but it makes the process much more difficult. So to make this simple, company comes back and says, hey, we want to put a pipeline across your property. You say, okay, fine. How much? Where is it? And how much do you want to offer me? And they say, well, we want to offer you $50,000. Well, you could say, look, I'm never going to agree to that $50,000. I really don't want it. I'll tell you what. The only thing that's going to make this ever change my mind would be $300,000. And you can pick your number, whatever that number is. Maybe it's $500,000. And the deal is this. They're going to look around. They're going to try to avoid you. They're going to do whatever they can to save money. But if they don't have alternatives and they need your property, they need that area, they need to run it across your area to link up to other locations, they're going to come back and knock on your door. They may come back and knock on your door and say, well, we'll give you the $300,000. Or they may come back and knock on your door and say, well, how about $120,000? That's the process. So again, don't agree to anything. Get your education, get informed, get somebody to assist you, but that's a good way to handle this process, in my opinion. So, survey permission. You need to understand what type of line they're requesting to survey, but even if you don't want a pipeline, you may want to just go ahead and see if this thing could possibly balloon up to be something very, very valuable in the future. You also don't want to spend a lot of time and money on a pipeline that you're never going to agree to. So you want to make this bare bones and simple. Yes, you can survey. Then if you come back and you say you want to put a pipeline on my property, tell me how much and where, and then we'll decide if there's a compensation figure and a location that makes it worth moving forward. In other words, okay, I'm not going to do it at $50,000 at this location, but maybe I'll do it at $300,000 at this location. If you don't want to do that, company, hey, great, not a problem. If you do, let's talk some more and let's get an agreement worked out. So that's a good way to handle that in a lot of cases. But remember, again, it's not specific advice for any person, but giving some general guidance and some things to think about. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 a.m., and I'm going to be right back after this short break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday on these stations from 8 to 9 a.m. And I'm going to, keeping you guys guessing a little bit here today. So I'm going to jump back a little bit to my script. And again, remind you, I represent landowners and only landowners all across Pennsylvania. And I should say landowners and also gas rights owners across Pennsylvania. And also, people across the country. I have some clients now in Tennessee. We have some active clients, I believe, in Texas right now as well. Actually, it's funny. And, I just thought of this. I have a client who is a Texas landman who has some gas rights that they acquired up in Pennsylvania. And guess what? That Texas landman who acquired gas rights in Pennsylvania is now a client of mine. I shouldn't have said it that way. They're a client of mine. And why are they a client of mine? What they did some research. They went out there and said, okay, I'm a landman, but I don't know what's going on up there. I know what's going on in the places of the country I work, but I don't know what's going on in Pennsylvania. So you know what I'm going to do? I'm going to go out and hire somebody, an attorney in Pennsylvania, to represent me and my interest in negotiations with the gas company. This is the true, actual situation. So here you have a landman who does gas work hiring a lawyer to represent their interests. And on the flip side, I had the same thing with a pipeline employee who hired me to represent them in their negotiations. And so my point to that is not that I'm some kind of great guy who is, everybody should hire me. That's not my point. The point is that people in the industry, a landman, him or herself, hires attorneys to represent their interest in these negotiations. I mean, what more does that tell you, or what more do you need to hear to tell you, hey, you should be getting some assistance? And like I say, I don't want the show to be a big giant commercial. I want it to be informative. Go to the websites, pagasleaseattorney.com, pipelineattorney.com. Want you to get information and be informed. And whether you hire me or you hire somebody else, you really should get quality, experienced assistance. It's super important. Landman in Texas is doing it in Pennsylvania. Why would you not do it? Somebody who's been doing this for years, and I think this person's been doing it, I think it's well over 20 years, and I had to check in, but I'm pretty sure that's what they said. So that just shows you the importance of this situation and how these companies operate. So somebody with extensive experience says, hey, I need to get some assistance to make sure I'm not being taken advantage of. So keep that in mind. A great indicator you should be getting assistance. Now, again, not to make this a big commercial, but I am jumping back kind of my earlier script. And also, who am I? What am I do? Doug Clark, Clark Law Firm, gas lease negotiations, pipeline water lines, giving you a break today on the royalty and royalty deduction issues, but very, very active in that area. Also estate planning, doing more and more work in estate planning as more of our clients and Pennsylvania landowners transitioning into getting the royalties and saying, okay, we need to do some estate planning. Got to get ourselves in line here, make sure that we're going to transfer these assets and the royalties and the gas rights to the right people that we want. Do we need a trust? Do we not need a trust? Doing more and more of that work. Gas lease amendments and modifications. 2 more clients this week with gas lease amendments and modifications. And one client, they had a Friendsville lease in this particular case, and now it's held in part by 2 different companies, one being WPX, the other one being Cabot, and these other companies are approaching the landowner for amendments and modifications. And the companies don't use the same forms, so they're sitting there and saying, wow, I have one lease. It's now split between these 2 other companies, and they're both asking me to amend and modify this existing lease. So those issues are very important that you understand them. And you understand, do I want to do this? Why am I doing this? And if I do this, what do I expect, or what's going to happen? What am I changing? What am I agreeing to? So those are very important documents. The amendments and modifications are very important, in my opinion, to understand, what you might be agreeing to. most important is to determine, do you have any leverage to say no? Because if you think you have leverage and you don't, that may be the worst situation. Because if you say no to amendments and modifications, or to an amendment and modification, and you don't have the leverage that you think you do, you could end up losing your lease, being not leased, which isn't always a good thing, because if you lose your lease, you may not have a new lease offer, or the new lease offer may be for little to no bonus money, and may be for a much lower royalty percentage than what was in your original lease. Now, on the flip side, you may have some leverage to maybe bump up some royalty or bump up a payment or something like that in order to sign this amendment and modification. But you have to be very, very careful. I caution everybody, the understanding of your leverage is critical, because most people don't have the leverage. By far, most people don't have the leverage to change this modification or to get royalties increased or to get a one-time payment or something to that effect, but some do. So you need to evaluate and understand, where do you fit in that process. I am Attorney Doug Clark. You're listening to All Things Marcellus. And okay, back to my script a little bit. I mentioned the websites. Been doing the show August 2010, so we're coming up here on 4 years. You can go to the websites at pagasleaseattorney.com. You can go to pipelineattorney.com. Check out the radio shows. We have them archived and available up on the websites. You can go back, check them out. We index them. What are the shows about? Pipeline agreements. Are they about gas leasing issues, royalty issues, deductions? What's going on there? We have shows for every topic out there. 150, well over 150 hours of radio shows available. And we're also, if you're interested, we're also putting them up now on YouTube, the audio. So you can go to actually YouTube, type in All Things Marcellus. You could type in my name, Doug Clark, Clark Law Firm. Check it out. You can access the shows there as well. We're putting those shows up now. We're putting up the next day. So we put them up here on Sunday. You can listen to the show every Sunday from 8 to 9 a.m. But starting Monday morning, come in, get them up there, get them up on YouTube, get them up on the websites. You can get access to those shows. So if you're not able to tune in every Sunday from 8 to 9 a.m., you can go check out pagasleaseattorney.com. You can check out pipelineattorney.com. You can go to YouTube. And actually, you can also go to iTunes. We have the shows that are up on iTunes as well, in the podcast. And of course, everything is free. You just type in All Things Marcellus, and you can check them out there anytime you'd like. Also, if you want to follow me on Twitter, you can do that at Doug Clark Law. I tweet articles, and I say this sometimes. We're kind of a hub. My office, the Clark Law Firm, we're a hub of information. Where, what I mean by that, with our royalty case, we have about 160 individual clients who we're representing in claims against gas companies for improper royalty payments. So, with these clients, that's just a sample. I have all my other clients we're working on with gas leases, pipeline agreements, well agreements, estate planning, all of these other issues. And so what happens is, clients see information that I may be interested in, or other clients may be interested in, and we welcome this so much. And they shoot me emails and say, hey, did you see this article? Or, hey, you might be interested in this article. So what we'll do, I'll check it out, and I'll say, hey, if this is something my clients or landowners may be interested in, we'll go ahead and we'll tweet that out, and we'll make that available for everybody. So good thing, if you're interested, if you do the Twitter thing, you can follow me at Doug Clark Law. And also, if you want to get me information, or you want to help, with this whole education process for our landowners in Pennsylvania, shoot me an email. You can go to websites. You can shoot emails through the websites at pagasleaseattorney.com and pipelineattorney.com. You can go check out there, shoot me an email, shoot me articles. We welcome that. We check them all out, and we'll put them up there, and we'll spread that information, because, as always, information is key. We want all of Pennsylvania's landowners to be educated and informed, and that's how you're going to make that best decision for you and your property. And remember, for your children and your grandchildren, for your family, for your legacy. Very, very important. Again, Doug Clark, from the Clark Law Firm, and you're listening to All Things Marcellus, and we're here every Sunday from 8 to 9 a.m. And I want to talk, just struck me there in my little pause. I thought about this royalty issue. I'm not going to stick on this long, but I want to say something that came up this week. We obviously believe, and I believe, that there are companies, and of course we often talk about Chesapeake as we see as the primary offender, who are not paying royalties in a proper fashion to Pennsylvania landowners. And there's a lot of information out there that supports this position. And again, we represent about my firm and the others I'm working with, approximately 160 individual landowners currently in our actions and our assertions and claims against Chesapeake. And there's other companies also involved in this process that we're looking at as well. So I'm talking to a landowner this week, one of the clients, about one of these issues. And as he was talking, he was mentioning the fact that one of his neighbors, had this position of, in a similar situation to what this gentleman was in, and said, my neighbor's like, well, we're getting something, so, hey, we don't want to be greedy, so we're just kind of happy with whatever it is that we're getting. Well, I truly do understand the mentality of not wanting to be greedy. I do. However, this isn't about being greedy. This is about something that you're entitled to. This is, in what our opinion is, this money in these cases belongs to you, that you're being overcharged, or that money is being deducted from your royalty payments that should not be deducted. So if they're giving you $8,000 in a month, but if they didn't take these deductions, you would be getting, say, $12,000 in a month. That's $4,000 that they're keeping, that, and say in my example, we believe they shouldn't be able to keep. So you say, well, I'm getting $8,000, so I'm just going to be happy with that. Well, that other $4,000, in our opinion, that's your money. You're entitled to that. That's your gas. That's from your property. And the idea of saying that that's greedy to request what we believe you've contracted for and what is yours, honestly, it doesn't make sense to me. If you were in a position where you had 10 cars and somebody came and stole 2 of your cars, and you said, well, I still got 8 cars, so, I'm not going to do anything about that. Well, I don't think you'd really think that way. That's not how people think. So the problem is you're not physically seeing this gas that's underneath your property. So when it's being extracted, in my example, and you're getting an $8,000 in a given month, but $4,000 is going to the company, well, in our opinion, in this example, that $4,000 should go to you. So over the course in this example of a year, 12 months, 4 times 12, that's $48,000 in this example. So $48,000 in 1 year. You can do a lot with $48,000. You can do a lot to education funds, retirement. I mean, obviously we can all figure out what you can do with $48,000, but that's 1 year in my example. And I stress this, my example. In 10 years, and they wouldn't stay this way, but if all numbers stayed the same, that's $480,000. Why should the company keep all of this money, which we believe belongs to you, and ultimately it will be decided? Why should they be able to keep this money when, if we're correct, the money should belong to you as the landowner? Well, because they gave you 70%, you should be happy when you're entitled, in our opinion and our claims, to 100%? It doesn't, that line of reasoning doesn't make sense to me, because if it did make sense, then with everything that you're entitled to, you should never get all that you're entitled to. So if you go to any time that you get something, as long as you're getting something, the fact that they're keeping something that they shouldn't keep, well, that's okay. I'm just happy I got something. Well, I don't see that. I don't understand that. This is your property, and many of my clients, this has been in their family for 100+ years. This is your property. This is what people have worked. You've paid the taxes. This is your gas. That's why they need to lease you. It's your gas. So we believe it's your money. So the fact that you're getting some money and they're keeping some money, that's not the way to look at this. The question is, all you should get is what you're entitled to. What you should get is what you're entitled to. Not more than what you're entitled to, but certainly not less, but also certainly not more. You should get what you're entitled to. And I say this all the time to companies. We want one thing from the landowner side. One thing and one thing only. We want you, company, to follow the terms of the agreement. Just like we expect from our side to follow the terms of the agreement. No more, no less. Let's all follow the terms of the agreement, which leads to also then, let's make sure that we negotiate an agreement that we understand, that has the best terms that we can obtain, and the terms that we agree with. Because too many times, the companies want you to change your agreement. They want things which aren't permitted in the agreement, but if you ever ask for anything beyond your agreement, you're never going to get it. I am Attorney Doug Clark. This is All Things Marcellus. I'll be right back after this break. Welcome back to All Things Marcellus with me, Doug Clark of the Clark Law Firm. And just a reminder, I've been talking a lot, and like I said, I don't like to make these a big giant commercial by any means, but if you are in need of any representation, you have any questions or any way we can assist you, you can always contact me directly at the Clark Law Firm at 570-307-0702. That's 570-307-0702. You can also check us out. Go to pagasleaseattorney.com. Go to pipelineattorney.com, whether you're looking for representation or not. Check out the websites. We're very proud of the sites. We get a lot of compliments from the sites. You want to check those out. Like I was talking earlier, a landman from Texas recently hired us. Well, came in contact and learned about us through the websites, listened to some radio shows. Now have a client from Tennessee, the same thing. And of course, many, many clients from Pennsylvania, New York, and New Jersey with Pennsylvania land and gas rights. So make sure, check it out. Great place to become educated, to become informed. We like to think of it as a very good resource for landowners who want to learn more about the natural gas development here in Pennsylvania. And again, if you're looking for representation, and I represent clients all across Pennsylvania who reside all across the country and obviously within Pennsylvania, you can contact me at 570-307-0702. Now, I want to talk briefly. I've talked recently in these last couple weeks a lot about damage receipt and releases. And what those are is anytime a company is going to pay you money, they're going to want to have something, aside from a lease, they're going to want you to sign what's called a release or a damage receipt and release. And for example, if a company's going to operate on the well site, or a company's going to install a pipeline, and you may have a lease agreement that says, or a pipeline agreement that says, the company has to pay you for crops and timber, or they have to pay you, the example I used last week is like a $15,000 standard fee. However, and that your agreement may say that they have to pay you that money prior to commencement of operations on the property. So here you go. They're about ready to start a well site, or they're about ready to start operations through the pipeline on the property. Well, they're going to come to you and they're going to want you to sign what's called a release. And it can be entitled in different ways, but it's a damage release. So what it should say is, in exchange for you signing this release, we are giving you, in my example, we'll just say $15,000. So for this $15,000, you're going to release or acknowledge that you're not going to make any other claim for crops and timber damage or whatever the case may be in this area where we're going to operate. You have an agreement that says you pay for crops and timber. Your release should say, I'm releasing and acknowledging that I've been paid for crops and timber in the area you're going to operate, not anything beyond that. If you start seeing language about indemnifying a company, paying lawyer fees, that shouldn't be in there. Most cases, confidentiality shouldn't be in there. You're merely getting what you negotiated for. So that's what this document should say. And I'm seeing companies who are starting to present these very, very broad and vague and enormous expanded release agreements, giving up your rights far beyond what you should be doing. And if they say, well, this is what we do, to me, that's a joke. It's not we're out there giving bad releases to people all over the place, so therefore you should sign a bad release. That's crazy. That's absolutely crazy reasoning. No, your release should be releasing for what you're being paid for and nothing more and nothing less. You shouldn't get $15,000 for crops and timber and then be able to go back to the company and say, oh, you're supposed to give me $20,000 if that wasn't your agreement. It should be very simple. I said to the company the other day, I said, look, we're not negotiating world peace here. A release agreement is one of the most standard, simple, basic agreements that you can deal with, but it has to be done right. So you can't sit here and expand it and make it so broad that you're getting all of these benefits when really you're supposed to be giving $15,000 for crops and timber. That's what it should say. So I've been going on and on with this process, and thankfully we have a few clients kind of in the same boat, but it's now become, it's almost a personal situation for me because I know what's going on, and here's what it is. The company is getting people to sign bad documents, and if we're able to get them to change this document, word may get out that not everybody is signing this bad document. So they're fighting and scratching and clawing to try to get everybody to sign this bad document. And then they're going to snowball it and say, well, everybody's signing it. Well, they can't say that if we're able to actually make this a fair agreement. So since they're having success and they've had success in getting people to sign very poor documents as far as the landowner perspective, they want to keep that up. And now they've ran into a roadblock, and they're fighting and clawing because they don't want to change. They don't want to give you a fair agreement because they don't want to have to give everybody a fair agreement. They want to have this agreement the way they want it written. And they want it written in an overly broad fashion to protect themselves in the event that there is a problem in the future. So you need to make sure that you're getting assistance again, and I know it's repetitive, but you have to get assistance with all of these documents to at least make sure. Now, some of these release agreements, this is my argument to the company too in this case. I said, look, I read release agreements, it can take me less than 5 minutes, and we're done and say, okay, yeah, that's good. But this thing, it's taken hours. It is crazy. But the problem is if there's a problem, you as a landowner could be in a really bad situation. If you don't care about that, well, then go ahead and sign it. But if you all of a sudden find yourself in that bad situation, I assure you, you are really going to wish that you didn't sign that document. So we want to make sure that you're informed and you understand these things. Also, with regard to this particular case, what's funny is it has changed drastically, and it continued to change over this past week. And we're now at a point where we're almost there that the clients can sign it. And the clients are very informed in this process, and they're saying, well, geez, thank heavens, because I didn't realize, what this was saying. And remember, when the company guy is presenting it to you, he's not presenting it to you and say, well, landowner, here's the pitfalls. Here's where it's not good for you. They're not saying that. How many people have ever heard a landman say that? Well, it's not good for you here. You should have this change. You should have this change. No, they're saying, look, this is standard. We do this all the time. All landowners sign this. Many other attorneys have signed this. All of those type of statements. Well, first off, I question it. Second, just because other landowners sign bad agreements, or maybe other attorneys, if that's true, didn't read them or didn't understand them, that doesn't mean that you signed the same bad agreement. Remember, always get that assistance and help. I am Attorney Doug Clark, and you're listening to All Things Marcellus, and I'm here every Sunday from 8 to 9 a.m. We only got a couple minutes left, and I'm going to quickly just say, because I feel obligated to do it, talking about the royalty actions, if you are a landowner and you are receiving royalties, and you're receiving deductions for such items as gathering and transportation, it is important that you understand whether these deductions are appropriate and being taken appropriately under your oil and gas lease. So what we do, and again, it's my opinion, you can get other opinions, but I offer free, confidential, no obligation whatsoever evaluations. You send me your royalty checks for a month, your lease, and I'll let you know whether, in my opinion, I feel that the company is appropriately taking deductions. I can't tell you if they're excessive, but what I can tell you is, in my opinion, is there a breach of contract, and are these deductions being taken improperly? So you owe it to yourself to get that evaluation. What you do with it is entirely up to you. I'll get back to you. There's no pressure. There's no obligation. You can contact me by telephone at 570-307-0702. Get that free confidential evaluation. Again, 570-307-0702. Contact me anytime. I want to make sure you're informed. You are listening to All Things Marcellus with me, Attorney Doug Clark, the Clark Law Firm. We'll see you next week from 8 to 9 a.m. Have a great week, everyone.